Okay, this is a service role for me. We had actually planned for my colleague, Meg Sattersworth, to be the interviewer. One thing that I did want to say is that, as I said in the moment of celebration on Thursday, and I'll say it again because now Philip Alston is here and he won't be able to escape as he did that day, is that everything that we're doing here, celebrating with the future work of the center, of course, builds on and would never have happened without Philip establishing the center and then working very closely with Meg on making it what it is now. And I'm deeply grateful to both of them also for supporting what we're doing now and for doing something that in the human rights world is very rare, which is supporting new leadership and passing the baton. And at the same time, supporting everything that we do with generosity and intelligence and kindness. And that's something that I cannot be thankful enough. So thanks, Philip. And also because I know that Philip, I don't know what he thinks when he sees this new logo. Like he said, like he would have never come. Anyway, and you should have listened to the music that Yusuf added to the logo, the video presentation of the logo. You would have cringed so badly. Anyway, so given that Meg was unable to be here, she really wanted to be here, but she also has a big job now. She is a UN special rapporteur, working with judges and lawyers, making sure that their rights are respected around the world. And of course, we thought that she would be the perfect interlocutor to have this conversation with Hilary. But unfortunately, she had an official mission in Mongolia. So that's the only reason why you have a very imperfect replacement talking with Hilary. But it really is a pleasure for me and all of us to have Hilary with us. I want to start with Hilary's academic record, because of course people want to talk to her about the ICJ, and we will talk about the ICJ, but she comes to that role from many years of pioneering international law and human rights work. So I thought that I would start with that 1991 Feminist Approaches to International Law article, which really, I would say, changed to an extent the whole field. It introduced a feminist lens on international law issues. But I want you to confirm one thing. So I've heard the following. I've heard that you wrote that article with the co-authors after a particularly frustrating conference where female voice was notably absent, at which point you and your co-authors retired to a pub and scribbled thoughts on a napkin that ultimately became this article. So notwithstanding the delightful lesson that this provides for students in the room, that thoughts among friends in a pub will make it into a celebrated, will turn into be made into a celebrated article. Your storied career in this space, of course, suggests a much greater driving force was at play. So can you comment on both the origin and the repercussion and the implications of the article in the last 30 years in 5 minutes?
Thanks. Thanks very much, César, and it's a pleasure to be here. And another thing that Philip Alston has done is to stack the place with Australians. So a little known fact of my CV is that Philip actually taught me, I don't think he remembers this, contract law. He was a special, but luckily for both of us, he left the area of domestic law. I didn't have good enough teaching to stay in the area of national law, so I've become an international lawyer. But the story about the birth of that article is absolutely correct. But it was really, and now this seems very strange looking back, but I think Christine Chinkin, my co-authors, and Shelley Wright, we had all become very interested in feminist legal theory, but we'd all assumed, I think, that it didn't have much to say to international law, because international law was all about states. And I remember we had been involved at our separate faculties in various sort of feminist initiatives, but we didn't see its relevance to our area. And it wasn't really that we were irritated by a particular conference. We did get together and we decided that we were sort of thinking, we were talking about some of these issues in the context of Australian law, particularly criminal law and family law. And then we thought we'll offer a paper to the Australian New Zealand Society of International Law meeting, and that we would try and think about how these ideas we were interested in applied to international law. We had no idea at all what we were going to say, but we expected that the paper would be turned down. So we thought it would be a provocation to some of our colleagues that we would offer this paper. We expected they would say no, stick to law of the sea or something safe. And but it was Professor Don Gregg, a colleague, then he said, no, that sounds interesting, please give the paper. And then we were terrified because we had to come up with some ideas. So it's really a product of thinking. These are in the pre-internet days, and we had to do the talking by letter and fax and telephones. I was at the University of Melbourne, and Christine and Shelley were both at the University of Sydney. So it is perhaps a good and encouraging lesson, I hope, to aspiring authors, that sometimes you do just have to dive in and try on ideas for size and borrow ideas. I think your own scholarship is very much a model in this regard. Try to look. We got a lot of courage from looking at the writing in international relations, that was sort of feminists writing in international relations. And that gave us, feminist geographers were of great encouragement to us reading, because I think there were many disciplines, feminist literary theorists, because really many other disciplines were far ahead of international law in investigating the impact of feminist theory. So we just shamelessly borrowed ideas from these other areas and put that together. I still recall Tom Frank, who of course is a great figure at NYU, who was then the editor-in-chief of the American Journal of International Law. And in a fit of hubris, we just thought we will, again, expecting it to be turned down, we thought we'll just go for the heartland, we'll go for the American Journal of International Law. And Tom Frank wrote to us many months after we submitted it, saying, never in the history of the American Journal of International Law has an article been reviewed so many times. We've got 19 reviews. I do have his letter somewhere, which I should bequeath to some institution, saying it's caused a massive, there's a deep divide in my readers as to whether we should publish it or not. But Tom Frank, with his openness, he said, I'm willing to publish it, but I don't think you've really given this article its best chance. I think you should go back and do harder work on it before he allowed it to be published. So it definitely has an NYU connection too.
Thanks for that backstory. I'm glad that this pearl that we found on the internet turned out to be true. You never know these days with what you find. Not a ChatGPT hallucination. So moving on to your career as an academic, but now in the role of leadership, of institutional leadership, you directed the Center for International Governance and Justice at the Australian National University from 2005 to 2019. And we looked at the website, and among the projects that the center were running then are some evergreen questions, like why are international human rights standards widely accepted in theory, but so hard to implement in practice? So I was hoping that you would give us an answer to that.
I think that lawyers tend to think about human rights law in quite narrow ways, and we're always looking for products of the law. So we expect, we think a good human right is one that one simply takes, and we see it through perhaps litigation, and then we see it having the result we often look for is in a court decision. I think that work that I did was when I got out of a law school and was based in a wonderful institution at the ANU, the Regulatory Institutions Network, which is still going strong, which had been started by a criminologist who also actually has taught in the global faculty at NYU, John Braithwaite, a brilliant and wonderful colleague. And he was interested in looking at ideas of regulation broadly understood. So the idea that law, of course, is one form of regulation, But John Braithwaite's views, and he's still going strong, and he runs his own wonderful website. I think it's johnbraithwaite.com, and I recommend it to all scholars. It's got all of his publications there. He basically made the point that we lawyers tend to take this very narrow view, but we have to look at what influences the course of events more generally. And so it could be the rules of etiquette, it could be there are many, many forms of pressure that can change events, and lawyers tend to focus far too much on the law and what it will deliver. So that research, I think that you're referring to, I borrowed some of John and his co-authors' ideas. They had done a lot of work on nursing home regulation, how are nursing homes regulated. And they'd made the point that in a lot of institutions there are plenty of rules dealing with nursing homes, and how can we understand the fact? So it's got a fairly good formal regulatory system, but we see in comparative studies that they did that in fact many providers of nursing homes, I think John and his co-authors studied Australia, Canada and the United States. Despite all these wonderful regulations, the situation in nursing homes is pretty bleak. Mm-hmm. So they drew attention to, for example, ritualism, which is something that I borrowed to look at human rights law. The idea ritualism involves, in the sense they use it, the idea that it's very easy to adhere formally to various rules, such as in human rights treaties, but the idea that many states will sign on to human rights treaties and perform them at one level, but work out ways to get around them in another level. So that was what that research did. So I think one has to take a broader approach to these human rights standards and treaties, and see that if we're just looking for a classic legal use of them, we might be disappointed. But as again your work shows, it's interesting to see the way that these standards can be picked up and used in ways that perhaps weren't imagined by their founders, by civil society obviously, but there are many ways in which they can be used. Again, the work of Sally Engel-Merry here at NYU really emphasised the way that international standards could be vernacularised and used at local levels, and that local translations of human rights themselves could influence international standards.
I'm so glad you mentioned Sally, not only because she was the person who introduced us to each other, but because, of course, she's a huge influence for all of us here at NYU and at the center. So thank you for remembering her here. So staying with the topic of efficacy, but moving on to your current job at the ICJ. One of the main criticisms of the US system is its lack of efficacy, impact on the ground. And then the ICJ is kind of a unique institution because despite the lack of course capacity of the court to ensure compliance and the fact that its rulings can entail far-reaching consequences, it does seem like the majority of the rulings are complied with and implemented by the parties to the disputes, and even recognized by third states. Just to give one example, recent example, in its 2022 judgment on reparations in the case of armed activities in the territory of the Congo, the court ordered that reparations should be paid in 5 annual installments of $65 million from Uganda to the DRC. And not only did Uganda comply with the ruling, it also made the first payment in a timely manner. So viewed in this way, what would you see as the singular traits of the ICJ that potentially lead to greater compliance, as opposed to what we see in many other realms, not just of international human rights law, but international law writ large?
Well, yes, it's interesting because often I get asked why isn't there better adherence to the ICJ's rulings? And of course there are some very famous ones. I'm thinking of Nicaragua against the United States. from the 1980s, where there are still questions raised about the enforcement of that particular judgment. But I think you're right. On balance, what is striking is that many decisions of the court that are adverse to a particular country are nevertheless followed. Partly, I think there are reputational issues for states, because I think many of them feel, well, if we were to ever want to use the court, then if they hadn't complied with earlier judgments of the court that were adverse to them, that would certainly put them in, I think, on the back foot. But I think also I've noticed, being at the United Nations for the last couple of weeks, that many states sort of use that information. I've had a number of states say, we didn't like the court's decision in this one or that one, but nevertheless we followed it, because I think that gives them perhaps some status, and they're very proud of that. We have, of course, my observation is that when the situation, I think in the case particularly of provisional measures, when the court's giving provisional measures, which by definition almost are very hot issues in international law, there was a very interesting article published in the European Journal of International Law blog just yesterday, I think, a very interesting study of provisional measures decisions and how often they're followed, because I'm conscious of some provisional measures that the court has granted in the not too distant past that have not met with a great deal of, well, obvious success at international law. So I think the court is perhaps likely to have more success on issues perhaps that deal with boundary disputes, with allocation of resources, but perhaps less so when it's dealing with questions that implicate the use of force.
Mm-hmm. Moving on, and this is, again, I realized, I made this comment yesterday, that I realized that the organizers of this conference, we thought that this would be the only time that we got to run this conference, that it would spectacularly fail, and we invited all of our favorite people to the one event that we're going to run, and now we have this dilemma of having relatively short conversations, opposed to extended conversations that we'd love to have with you and the rest of our colleagues here. So I'll ask a final question, more prospective questions about the court's role. As you know very well, there is an advisory opinion request pending on climate change. And many people around the world are following the developments with the case. Many states are preparing briefs. The youth climate movement initiated the whole process that led to the UN General Assembly asking the question to the court. So without, of course, I know that you cannot comment on any detail of the AO. What do you see in general as kind of the opportunities of the moment and the constraints of the court in dealing with such a large and existential challenge to not only to human rights, but to international law and to humanity itself?
I think historically the court, when it, of course, it has these two primary jurisdictions, contentious cases and the advisory jurisdiction. I've never sat on an advisory opinion before. The most recent one that the court decided, or the court rendered, was in, I think, 2018 in the Chagos Island case. But certainly my observation, more as a scholar than from inside the court, is that the court takes quite a different approach with advisory opinions, because its role is to, the court always likes to use the word illuminate the United Nations work on an issue. So it's not as constrained as it is in a contentious case, where it sees its role as really responding to a dispute, a discrete dispute between two states. So I think this is a really appropriate jurisdiction to bring these issues in. Of course, I know there's enormous hope, and of course this isn't the only advisory opinion, because there is an advisory opinion pending in other courts and tribunals too, and one hopes we'll have the benefit of that to consider as well. But I think that my observation is that the court does see itself very much as a creature of the United Nations and sees, particularly in its advisory jurisdiction, the need to respond as best it can. And all of us, everybody, everywhere is affected by climate change, so it's an immediate issue. The question that the court has received is certainly in very broad terms, and of course that leaves quite some room for interpretation and also identification. What are the legal issues? Because the court will generally, it tries very much as far as possible. Every case that comes to the court has a political context, but my observation is the court tries as hard as it possibly can to identify the issues that it can see have a legal dimension to them to say something on. So I think the court will take this task extremely seriously. I just say it will rely on good quality submissions from states, and of course civil society groups also have the opportunity to submit. They don't have a right necessarily to appear to talk to the court, but they certainly have the right to submit documentation to the court. I'm hoping that the court will receive so much high quality information that this will really, really assist it in reaching its decision. But there's a strong sense the background of the case is very well known to all members of the court, and while there will be this sense of we will stick to the law, I would be confident whether I'm on the court or not, because it's not necessarily clear that I'll be on the court when that's considered next year, but I'd be confident that they're aware of the significance of this decision, and as I say, we'll be looking for and very grateful to have valuable submissions before it.
Thank you so much, Hilary. Please join me in thanking Hilary for being with us today.
Thanks so much.